included in the
a petition before the High Court of Telangana. Brackets. What is the writ petition number, ma'am?
Please, Lordship.
20212 of 2019. Stop. It has been averred in these proceedings that judgment was reserved by a single judge or a division bench. The judgment was reserved on 31 January 2023 by a division bench of the High Court.
Division bench.
Stop. Since the judgment has not been pronounced, the petitioner initially wrote a letter to addressed a communication to the Registry of the High Court on 3 April 2024, highlighting the delay in the pronouncement of the judgment, and followed it up with a representation and followed it up with a communication dated 27 April 2024 to the Chief Justice of the High Court. Stop. The pronouncement of the judgment is still pending. Full stop. We are of the view that, bearing in mind the guidelines which have been issued in nature, despite this position, it's been reserved, right?
Please, Lordship. It is there at page 37, showing as pending CAV.
Despite the fact that judgment has been reserved, the grievances that is still awaiting pronouncement. Learned Brother says that the status which you have annexed doesn't show that it has been reserved.
Lordship, we kindly have page 37.
37.
P2.
1 second.
Listing date. It is at from the top. Listing date, case status, pending CAV.
So that is the case status you must have uploaded from the site of the High Court. Where is the order? Is this the order?
Even that order, only single order has been uploaded till now, Your Lordship. That is of 2019.
There is no order as such.
Lordship, none of the orders has been uploaded till now, Your Lordship.
Which was the bench which had heard the matter?
Honorable Justice T. Vinod Kumar and Honorable Justice P. Sri Sudha.
Included the arguments.
Please, Lordship.
The court must have passed some order.
Yes,
Arguments.
as per the lawyer, we inquired. They said it was reserved for the judgment.
From the record, we do not. From the record, we do not find any specific order of the High Court reserving judgment. Stop. However, the petitioner has relied on the case status of the matter as reflected on the website of the High Court. We permit the petitioner to move an application before the Registrar General of the High Court, setting out the grievance. Stop. If this is done within a period of 2 weeks, the Registrar General shall place it before the Honorable Chief Justice of the High Court of Telangana. Stop. The Chief Justice may thereafter, on the administrative side, look into the grievance. Thereafter, issue appropriate directions in the event that there is substance in the grievance of the petitioner. The case has been pending judgment despite the judgment having been reserved. The petition is accordingly disposed of.
What had happened, Manoj, the e-auction was allowed. 6 people participated. One of them, the bidder was below the reserved price of 18.4. And that has been given today, despite the fact that 5 others
but
had given it.
Three times the auction was a failure, right?
And just 1 second, Manoj. What had happened is,
now at the third auction, did you also bid?
No, I was not permitted because by the order dated, Manoj, on page 58, by the order dated 30th of April, the court restricted it to 3 people. IOL said that we have withdrawn the earnest money. So was done by the others. and one other person was also not invited. So they invited only 3. 2 of them conveniently, it's a collusive thing, 2 of them conveniently withdrew, and the one who was granted,
But you withdrew your EMD?
so did others also, but they were invited.
Now just give us some facts, because let's understand
Please.
what date are the auctions taking place and
I'll give the date, Manoj.
what is the date of the first auction?
Manoj, the e-auction notice is on 15/12, Manoj, and extra P3 on page 36.
1 second. Notice is on 15?
Yes, Manoj.
23.
Yes, Manoj. The auction was to be held on the 21st and 22nd December, Manoj. Then there was a corrigendum, Manoj,
Yes.
on page 54. And then it was rescheduled for 12/1, Manoj. 12/1/2024.
Then
Manoj, in this, Manoj, L1 bidder was, Manoj, at 25.24 sharp steel, Manoj. There was another
it at 23.44, right?
Yes, Manoj. And I was the third,
You are the L3.
L3.
Right.
So, Manoj, what has happened now is, I was L4, Manoj. I was L4.
Now what happened in that first auction?
Manoj, when Manoj, the auction was to be finalized, Manoj, the successful
The
bidder
bidders withdrew.
saying that there are complications, I did not know of the difficulty.
Right.
So he withdrew.
So the first auction was cancelled.
Yes, Manoj.
All right. We'll proceed step by step. Then second auction takes place.
Manoj, this is where the problem is. For second auction, the court itself, Manoj, finds 3 bidders. And that is on page, Manoj, this
That
is
is the order of 30th of April 24.
30th of April 2024 on page 57.
Just 1 second. Let's see.
This is where we were not there, Manoj. OL and other parties were there. The necessary parties to winding up, Manoj. And now this is, I will read, Manoj, the second paragraph. The official liquidator shall, within a week of communication of this order, convene and hold a fresh auction inviting 3 bidders. Sharp Steel, the one who did not, Manoj, he was an L1. Did not, Manoj, took it, was invited again. Then is, Manoj, Square 4. Square 4 is the one who did not, cannot be called a bidder because he bid less than the reserve price. And Avirock is the one who withdrew his EMD 1 month prior to mine, Manoj. So, Manoj, all 3 actually are defaulters.
The Annexure P? 30th, yeah, I got it. P5.
This is on P5, page 58 is the relevant part, Manoj.
Mukherjee and the official liquidator, just read that order.
Yes, the official liquidator shall, within a week of communication of this order, convene and hold a fresh auction inviting 3 bidders with Sharp Steel Industries, Square 4 Logistics and Avirock meeting. Manoj, Sharp Steel is the one who was successful. He was the L1 bidder, did not take it. 2, Square 4 is the one who did not bid even the reserve price. So he cannot be called a bidder in the first. Avirock is the one who withdrew its EMD even prior to mine, Manoj, 1 month prior to me. But they were called, Manoj, indiscriminately on the suggestion of OL.
Now, did you challenge this order?
Yes, Manoj, I challenge this order, Manoj.
Where?
Manoj, this order, actually, Manoj, we did not know. I was not a party, so I challenged it in an IA.
Was not a part.
We challenged 16th May order, Manoj, which is...
He filed a recalling application
On respect of this 30th April order.
16th May. For 16th May order,
Where is the 16th May order?
When is impugned order, Manoj, in this?
16th May is not the impugned order, it's page 57 is the 16th May order.
Manoj, that is, he is reading the other writ. Manoj have 2 SLPs.
It is 37
Manoj, 2 SLPs and 1
May, the first matter, 16th May order is the impugned order.
Okay, that's right.
Right?
Yes, Manoj. So 16th, Manoj, please see the 16th May order, which is, Manoj, the impugned here. I was supposed to, otherwise, because I had challenged this order in IA.
Who is your client, by the way?
My client is Shiv Shakti, the person who provides us security services. My appeal was before the appeal court, and my lords, if my lord sees the 16th May order.
Are you willing to deposit 23 crores here in our court? Are you willing to stand by your offer of 20? Your case is that you are offering 23 crores.
At that time, yes, my lord.
The offer which has been accepted is of 18 crores.
My lords,
Are you willing to deposit 23 crores?
I am ready to deposit right now, my lords, over a period of time, which time will be given 20 crores to start with, my lords. Why I am saying, my lord, it will be two, my lords. This person.
Look, you have a higher offer. My lord. One second. We want to test your bona fides. Otherwise, what happens in all these auctions? Somebody will find.
I will deposit, my lord. Why I am saying 20 crores? When this deposit auction happened, my lord, and when these people were withdrawing, there were certain, my lords, liabilities which were not known. That is why people withdrew. I am saying I am still higher bidder, my lords. I am ready to give 20 crores. It is 2 crores more today. Because this is, I was not invited. I would have given 2 crores plus.
Why did the court restrict the auction only to 3 parties? Who are you appearing for?
I appear for the secured creditor. What happened was, first application was by the secured creditor for a private sale, because sale was not happening at all in this. Therefore, initial application was for a private sale for 18 crores. Thereafter, the court again gave one more option for auction. Then this auction happened.
But the auction, why did the court restrict the auction only to 3 parties?
Because other 2 had gone. That time, this gentleman had withdrawn his EMD.
But the other person who's one of the 3 who participated, who was allowed to participate, he also had withdrawn his EMD. That's what
Later, my lords.
No, 1 month prior to my lords.
just 1 month prior to him, that man had Adorik, no? Adorik.
Yes, my lord.
I was in item 37.
29.1. I did on 29.2.
My lords may see page number 57 in item 37, annexure P5, that 16th May order.
Yeah.
My lords, Sharp Steel, the main party, withdrew its offered bidders letter dated 6th May 2024.
My lords are not talking about Averick, my lords.
And my lords, in the same paragraph, page 59, where my learned friend is appearing, RSEC, and there was a joint lenders meeting in which this private party was approved as a buyer.
We will issue notice here. I think we'll issue notice here. We'll issue notice here. And who's the successful bidder? Is he a party here?
Yes, my lord. And we have
You're not a. What's your client's name?
Square Force.
Square 4 Logistics. You're not implemented Square 4 Logistics?
They have not, but they're not a party. We are challenging the order. We have not completed.
Complete them.
Yeah, I will.
Also, the other secured creditor, X-Ray, is a higher secured extent of 80. Ascel is there, they are only 30 crores. Aspect, which is
All that you implement the other secured creditor as well as the successful bidder.
I will.
And make it returnable in 2 weeks and dispose it off on Monday.
Lords, conveyance deed may not be, my lords, meanwhile.
Learned Counsel of
Conveyance deed.
My lords, my grievance is at page 16, the 16th May order. The official liquidator was directed to release my claim by 31st of May 2024. Now, if my lords are staying the order, then my payment won't be released today.
You are the security agency, right?
I'm the security agency employed by the official liquidator.
We are not bothered about the security agency. Let him pay whatever are the dues of the security agency.
Let him make that deposit, my lord.
Yes. The grievance of the petitioner is that the High Court, by its order dated 30 April 2024, restricted the bidding only 3 parties to the exclusion of the petitioner, and as a consequence, the petitioner was not allowed to bid, though its bid in the earlier round was in the amount of rupees
23 crores plus.
23.44 crores. Eventually, the bid which has been accepted is stated to be in the amount of rupees 18.13 crores. Full stop. The successful bidder, Foursquare
Logistic Park Private Limited.
Foursquare Logistics Private Limited. Please give the name. Has appeared through counsel in these proceedings. Full stop. We direct. Full stop. Notice shall issue. Liberty to implead. Liberty to amend the specially petition so as to implead Foursquare Logistics and the and ASREC, who is the other secured creditor, the party to these proceedings. Full stop. Notice shall issue to the newly impleaded parties. Full stop. The proceedings shall now be returnable, thus the permitted in addition. List on kar do after 2 weeks on a Monday. In the meantime, we direct that no deed of conveyance shall be executed. However, the above order shall be conditional on the petitioner depositing an amount of rupees 20 crores.
Lords, I'll give it over a period of time, Lords. 3 weeks, because they are being given money immediately.
So we'll give you 2 weeks' time. All right, notice shall the petitioner shall deposit an amount of rupees 20 crores before the registry of the High Court of Calcutta and produce proof before the registry of this court in regard to the deposit so made. Full stop. Failing deposit, the petitioner shall lose the benefit of this order and the specially petition shall be dismissed without further reference to the court.
Only thing is there are 2 secured creditors. My lord, we will implement both. My lords have said one.
ASREC. All right. What we'll do is
ASREC and ARCIL.
the other one is RCL is already a party. So the other one. And we keep it if he deposits 20 crores and we are giving him notice and keeping it after 3 weeks. If he doesn't, let us first see the color of money and deposit before the Calcutta High Court.
This order shall not come in the way of my payment. That is the only.
We have not said that. We are not concerned with the security expenses. Yes. You didn't deposit the mandatory 50%.
Because the challenge was in the revision.
No, but there is a I got your point that your challenge is about the valuation.
Offset price.
But right. Yes. But notwithstanding that, there is a recovery certificate against you. You can't get over this requirement under section 154(2)(a) of the Maharashtra Cooperative Societies Act by saying
May I read the section, my lord, at page 19? May I read the section, my lord, at page 19 for a moment?
Says against a recovery certificate.
Against recovery, 10.
But yes, you are tacitly impugning the recovery certificate also, because otherwise, if we accept your point, then people will merrily start challenging all intermediate stages of the proceeding.
I can't pay, therefore recovery certificate is issued against me. I'm suffering the recovery certificate, option proceeding have been initiated. Only thing is, my lord, even if
How much is the amount? How much is the amount of the recovery certificate?
Recovery certificate is 17 lakhs and 11 lakhs, my lord. And one thing I must point out, 2016.
You have to deposit that 50%. Otherwise, these are all dues of a financial institution.
Here is man, my lord. This is the only agriculture land. My lord, 2016.
What do you have to say?
I am appearing on a caveat for the bank, my lord.
Yes.
So far, first his legal aspect is concerned that he has not deposited, he is not entitled. That is one aspect.
But he says that
Aspect about the valuation of the property.
No, he says that the requirement of deposit applies only where he is challenging the recovery certificate. That's the language of 154. And I'm not challenging the recovery certificate. What do you have to say to that point?
But my lord, ultimately, auction is in consequences of the recovery certificate.
He's right actually, because
Then you can.
May I read out the language, Manoj? May I just point out, so far as language, there is a clear distinction. 2A was introduced subsequently by a amendment in 2000, Manoj. Before that, Manoj, page 19.
But if we accept this, what will happen is that ultimately, what is your grievance? Your grievance is in regard to the recovery certificate.
Manoj, may I point out, recovery certificate, I don't have money, I didn't file a revision, so far as the recovery certificate is concerned, that is final, so far as I'm suffering that. But then even if I'm a defaulter, I have a right that my property should fetch the best possible price. Ground, the revision court has accepted my plea that it is being sought to be disposed of for a throwaway price. That is my specific case, and this is my only agricultural land. Not Article 300A, and even if I consider that I'm a
What's
defaulter.
to be done? 3 times the property has been put up for sale and there is no buyers. This happens in all these auction sales.
No, the upset price was set aside at my instance, but court has specifically accepted the fact that it is not the market value of the property. But bank also, as your lordships have repeated.
How much have they fixed the price, upset price?
Well, it's now third time it was fixed at 37 lakh rupees. And I must point out to my 2016. 2016 I purchased the property. The sale deed is on record. I purchased it for 41 lakh rupees. After 8 years, the property is bound to appreciate. And not depreciate is what's my specific.
But the point is that, if it had appreciated, somebody would purchase the property in the auction. The fact that it is not being sold, therefore they have to reduce the upside price.
Not to this extent, and my
3 auctions, it has not been sold. Therefore they have to reduce the
Lord,
upside.
I must convey that on 6th auction had happened, and the highest bidder was of about 45 lakhs, and the bid has been accepted for the 45 lakhs. The government valuation that DDR has rightly considered, government valuation is about 20 lakhs 87,000, and the market value was considered as 37 lakh 89,500. When DDR passed that order, the 45 days was granted to him that you please bring the purchaser that on your price. He failed to do that. So ultimately, my lord, this is the best price which has been fetched right now. Not in. May I just point out?
No, sorry, it will not. Shall I dismiss? Yes. Thank you. Thanks.
I am obliged. My lord,
Item 15, yes.
I have filed a caveat in this matter, but I couldn't file my appearance. Physical appearance.
Give us slip.
I am your obliged.
In this,
Sir, one more classical PILU. Writ petition for a direction to the Union of India to take action against cyber terrorism.
no effective law because we all are
The only thing which I can say is on all Mondays and Fridays when your petitions come up before us, we get some comic relief, So that's all I can say.
that obviously was not corrected. But separate issue, this is cyber terrorism, we all are affected by this. Any site of aims was hacked, Some strict provisions, that's all.
This is not part of the judicial domain. Government is, you have laws today.
Response only,
Thank you.
And I'm withdrawing this.
Yes. Withdrawn.
Since orders are not being complied with,
We will issue notice.
they want 80 days to
100%,
years.
yes. And we'll this. To notice, return of law, keep it after 2 weeks. Personal presence is dispensed with at this stage. Liberty to serve Ms. Garima Prasad, learned AAG, Standing Counsel for the State of Uttar Pradesh. I told him give us specified date. Maybe another one. The rights to dignity of
मैंने तो बताई
police officer to
ये भी मुझे याद नहीं था किस तरह का नाम लगा था लेकिन हाँ इन्होंने भी बताया कि इसके बजरी 10 की भी थी
How do we monitor those directions then? You want the appointment of women doctors in district government hospitals to conduct medical examinations of sexual assault victims. It's also a question of availability of doctors, not just a question of issuing general directions. The issue is of availability in that particular district. And so far as investigating officers, etc., are concerned, you have provisions of the law which are in place. That's a matter of implementation.
It was just one submission. In some offences, the accused, the victim's examination has to be conducted by a woman doctor as per Millard's subclause 2 of section 27 of POCSO. Millard, just juxtaposing that, I am saying, especially in cases of a women public prosecutor, they could be appointed in cases of sexual assault. Millard said the PIL could be limited to this aspect, Millard.
But how can we say that in a case involving gender violence, only a woman public prosecutor should be appointed? Why should we presume that, anybody other than a woman public prosecutor will not be effective in rendering duties? There's no such presumption for us.
There's another aspect involved in this PIL, that supposedly there is an FIR registered today. Subsequently, the sections involving rape or sexual assault get involved. Ultimately, then there is no provision for the FIR to be struck down from the portal, Millers. Because ultimately, if there is an FIR involving section 376, it should not be there on the portal. But sometimes in cases, these sections get involved at a later stage.
Mr. Chaudhary, you do this. You bring up specific case before us with a specific grievance, we'll deal with it. And then we can see what general directions to accept.
Just grant me 2 weeks time. I'll come up with specific certain cases.
Come up with a specific case. We'll allow you to withdraw it at this stage. Okay? At this stage, withdraw.
Item 18, it's the same petitioner.
Same here also. Amend the practice and procedure rules.
Because the victim does not get a right otherwise, unless he is informed, because he cannot exercise his rights. Though the Jagjeet Singh judgment provides that he has an unbridled right, but unless he has the knowledge of that right, how will he exercise that right? In CRPC, there is no provision of a caveat. In Supreme Court, though we can file a caveat, but that has to be renewed every 3 months. You must always the victim. Millers may permit me to withdraw, Millers. Much obliged.
Item 19, your lordships may kindly see I appear for the petitioner.
Against interim orders of the High Court.
No, this is a case where there is a moratorium issued and the writ for recovery is going on, my lord. Section 14(1)(a) is clear, shall not be instituted.
Proceeding is pending before the High Court?
Yes, ma'am.
Yes, my lord. And
Mr. Tripathi.
sorry, my lord.
Point it out to the High Court, Mr.
We pointed it out. Please see what the High Court says at my lord's page 21, para 16. Please see that, my lord.
On the same day, there was a moratorium. Mr. Doctor had appeared for us. He pointed it out to the High Court. The High Court, my lord, says in para 16, page 21, we accordingly direct that a defaulting company, I am the IRP, my lord, defaulting company, albeit not to be told that it is facing insolvency proceedings, the usual mantra. Well, that's how it has been dealt with. As also its subsidiaries in their own wisdom to take a reasonable approach and make an endeavor to resolve the issue. Well, this was pointed out. Our solicitor's letter is there, which is in the additional document, my lord, at page 15.
Oh, yes, what is the position?
Manoj, may I just give me 2 minutes? Manoj, this is a matter, and I'll come to the insolvency issue in a second. 5,000 crores is owed to NCD. Went all over the country trying to attach their writ petitions filed, dismissed by the High Court. They came in an SMP, dismissed by this court. We went all over. No one was even attaching their properties all over. Ultimately, we had to file a writ petition in the Bombay. In every account we went to, they withdrew and had owed 1 paisa or 20 rupees left in it. Those are the standard figures in every account. Ultimately, the Bombay High Court came down heavily on the authorities and said, how can you let public money go in the manner that you are? Finally, the 3 orders that my learned friend are referring to, what do they say? The moment you bring it to their notice, the court will not proceed with the company. These are pertaining to subsidiaries. The insolvency is not on with the subsidiaries. These are places where you want 99%, 100% of the subsidiaries. And new contracts are being used. The improved orders that one can say that how can public authorities give contracts to parties who in collusion are defrauding parties to the tune of 5,000 crores? And what does that friend? What he doesn't point out is the first impugned order that he refers to is dated 21st/3/2024, on which date the court directed the subsidiaries to place on record only their details of assets. On that day, no insolvency order passed. Insolvency order, the admission order comes on 28th of March 2024. On that date, I am instructed to say a parallel proceeding happens in the High Court. They do not point out to the High Court that it's an admitted petition under Section 7 or 9. They only say we are facing CRP procedures.
No, that's not true.
My lords, on 11/4/2024, that is a day before the hearing on 12/4/2024, they filed an IA annexing the order. We don't even know whether that IA was placed before the court or not. So what my Lord the Chief Justice said right in the beginning, if the court proceeds with the matter pertaining to the corporate debtor, despite the order being pointed out to them, bring an application on record, point out to them there's an admitted CRP, you can't proceed against the corporate debtor. That's one part. But your lordships against pre-interim order are told that the High Court should not proceed against the subsidiaries. All subsidiaries where you're diverting money, all subsidiaries where contracts are being awarded, we should not proceed. The High Court consciously lifted the corporate way. This is a classic case, my lord, where we have gone all over recover a penny against this party where 5,000 crores is for. The Bombay High Court came down heavily in the authorities, and that's when the attachment started. Now, whether the attachments made before the admission will carry on when it is, that's what the CIT to decide, or for the High Court to decide. What is so extraordinary that this court should today exercise its jurisdiction and intervene in a matter like this, and especially in mind, if you point out to the High Court there is an admission order today, and the High Court proceeds against the corporate debtor, then maybe you have a cause of action. You've done interim order in this matter, wherein, as I pointed out, against the first interim order, there is no order. On the second order, you point out we are facing it, don't point out it's admitted. And what did that order say? It just told them to disclose assets in the matter. Their biggest concern is that these attachments which are being made and which are being made against the subsidiary companies are the only source through which a public authority can today recover some amount of public money at all. So they want the entire thing to be brought to a standstill and conclude the whole issue.
Alan, my friend is plainly wrong. He has moved a Form C before the Malod's IRP. This is as a financial creditor, the banks have come. They have come as an operational creditor. They are doing all this, Malod, so that they can jump over.
Is it correct?
I am the IRP.
Taken are not against the corporate debtor, but against the subsidiaries.
No, my lord. I'm sorry, my friend is wrong. The shareholding of the company, which is the corporate debtor, is the asset which is sought to be attached. Let that be clear, my lord, that no part of the asset of the corporate debtor can be dealt with.
Now,
what they are seeking to do. Please see the prayer in the writ petition, which my friend doesn't point out to your lordship. The prayer in the writ petition is that please proceed against the insolvency proceeding. I'm sorry, my lord, that writ has to go. Please see the prayer at page 424. And my friend.
अभी की तैयारी को लेवल अप करने का वक्त आ गया है. आप 11th से 12th में तो आ गए हो और आप
dubious institutions in the country with thousands of crores my lord going the wrong way. I am a toll collector and they have raised a demand and they have gone to execute it without it being adjudicated.
Just kindly see page 4 of the order. It says category about the court determiners. The order of the High Court.
But the High Court is seized of the matter. Why should we entertain it at this stage? I mean,
reason,
but the writ can't go on without the writ petition.
Use of 5,000 crores.
No, man, I'm sorry. No, let my friend show the basis of the dues of 5,000 crores. Their own assessment.
Today. I have.
My lord, that's not been adjudicated. MCD of Delhi, your lordship knows it has thousands of people on the road who don't exist. Sorry, my lord.
I'm sorry.
Now, Lord, there is no adjudication of 5,000 crores. I am a toll collector. From where will I? Where is the question of 5,000 crores? That's not the recovery of toll. Is my friend saying that there is a toll recovery of 5,000 per annum for MCD? What is my friend saying? Lord, this is all ipse dixi. Some officer in MCD thought it's a great idea on their claim untested. And that is what the IRP has asked them when they begin.
This order,
yes, my lord,
please stands over the proceedings to 12th of April 24.
That's right.
What is the operative direction in this order?
Yes, please see the previous order of 21st March, which has not been, my lord, stayed. Please see what it says.
And next date is July 15th. First order of
just let me finish that moment, my lord.
Directed to place on record details and documents which provide for information regarding
no, my lord, please see para 7, which my friend is not.
One second, this order which Mr. Tripathi was relying upon, para 16, we obviously direct the defaulting company. Yes, not to be told that it is facing insolvency proceedings, the usual mantra. Also, its subsidiaries in their wisdom to take a reasonable approach and make an endeavor to resolve the issues. We shall hear the parties on the adjourned date of hearing. We accordingly adjourn the proceedings to 12th of April 2024.
After that, it has not come. Let us please see page 4.
What do you agree by in this order?
4 para 7. Which is a direction.
Which is the order you are challenging, Mr. Tripathi?
Both of them.
So this order now, what is the part which affects you?
Not the law is as laid down by your lordship.
What part of this order affects you?
The part of the order which affects me is that no proceeding, whether to participate actively or otherwise, constructively or otherwise, can lie once because there is a moratorium against me.
Where is a restraint by the High Court contrary to law here?
Yes, please read it with para 7 at page 4, which I have also challenged. Please see that only for a moment.
All right.
Page 4, para 7.
We'll see that.
Yes, grateful. Para 7. In the circumstances, we are of the opinion that Tehsildar needs to take all steps to advance recoveries as law requires him to do. Now, this part, it has to be made clear that this can't happen. That is not clear. Tehsildar is proceeding.
Were you before the court when this order was passed on the when this order was passed by the High Court?
Yes, I was. This order was prior to the moratorium.
Oh, therefore, prior to the moratorium.
That's that. So it can't now continue. That's all what I'm saying.
When the court passed this order on what is the date of this? 21st of March.
21st. Yes,
the High Court was perfectly justified in passing that order because there was no moratorium as on the date of this order.
Let's assume so, though according to us, no, because the amount is not admitted.
Moratorium, according to you,
yes,
to being later.
On 28th.
28th.
On that day, Lord, this order should have been stayed. This order is continuing. The Tehsildar is proceeding.
The High Court is seized to the matter. You argue whatever you want to show.
Lord, I have pointed it out to the High Court. High Court says we are not to be told that.
There's all
I am in IRP. Lord, I'm so sorry.
These are all page 22. Public authority.
Please see page 20.
No, Lord, kindly see what has happened here.
Coming up before the High Court.
No such stage.
Only 1 second.
Would your lordship keep saying.
Tripathi is there, not two people arguing. Yes.
I'm sorry, but he appears for the company. But I appear for the IRP. I am purely an IRP. I look
He appears for the IRP.
I'm together.
very well. I'm so sorry. I heard he's appeared. No. Of course, only one person. I quite see that. Audium partum can't be taken to that level, Manoj. I see that. I apologize for the confusion.
Why should we interfere at this stage?
No, Manoj, may I only
It's
say
not matter for us to interfere at this
no,
stage.
Lordships may make Manoj kindly see. I am Manoj answerable to the
You point out the provisions of law to the High Court. The matter is pending before the High Court. The High Court will deal.
Lordships Manoj at least
Order contrary to law, then come here.
I appreciate that. But may I say this, Manoj?
Get some.
Manoj, may I say this?
Now we are proceeding
After 28th of March, Because after 28th of March, the matter has not come up. Would your Lordships please say that on mentioning it will be taken?
Not at all. We're not interfering. Yes, item 20.
Wait, please, minutes. It's a partnership firm that got dissolved long back, and now an erstwhile partner who got his share, everything settled through registered documents, comes back and says there was an income tax right vis-a-vis one of the partners, and then it came to light that he purchased some extra property. That's why everything should be open.
Settled, Mr. Shishadri, what was settled before the Lok Adalat
Yes, minutes.
was relating to a suit for specific performance.
Yes, minutes.
Which was filed by the petitioner's MD of Sama Construction.
Yes.
Now,
He takes advantage of that document.
you can always raise all defenses under Section 16.
May I submit one thing? Gross abuse of process, in the sense, once they've all retired and they've just left Millers, now they've been drawn back into this cauldron of litigation for no reason, just because he wanted to have an extra pound of flesh. There could have been other ways. Millers, my lords, my kindly see Millers. The reason he has given, he says that it was an antedated document which was executed in 2015 as if it had been executed in 2007. He willingly, according to him, subscribed to that one.
There's a settlement or otherwise will be looked into by the arbitrator.
My lords, may kindly see one look at page 11 minutes.
That's my
Where the plea has been taken, the document is void. Not even a sentence should be binding on either any of the parties to that one. Still he says that I should invoke the arbitration.
You can still argue that before the arbitrator.
Millets.
Whether the document is void or otherwise.
But the document has been dropped off its validity because of, they say that a fabricated one, Millets.
Not a case for us to interfere.
And Millets, in fact, through a registered document, he got his share.
The High Court under Section 11 could not have gone into these issues, Mr. Shirade.
Precisely, Millets. And my lords, may kindly have a look at page 11.
They've appointed an arbitrator. You argue whatever you want to before the arbitrator. Thank you. Dismissed. Yes.
May I just plead, Millets? May I plead one thing, Millets?
Yes.
May I plead, Millets, since your lordships, it's fallen from your lordships, please allow us to have that as a preliminary issue, and then if at all it survives, then I could face it, otherwise it has to be shut out.
Who are you appearing for?
It's corrected, man.
Slightly different argument. Clarification from your lordships may suffice, Manoj. Your lordships be kind enough to see the arbitration clause, Manoj, which is that.
What is your contention?
Manoj, my contention is this, Manoj, that the arbitration clause is limited. There are two agreements, 2007 and 2015. Arbitration clause is only the first agreement, but admittedly there is no arbitration clause in the second agreement.
Raise that under Section 7, Section 16.
That's all that I'm saying. The prayer that has been allowed is reference of disputes under both agreements.
But you can
Yes,
raise.
please clarify that.
Why do we have to say that? You have a remedy under Section 16. Why should we clarify something which is implicit in the act?
Please see the order of preference.
You can look. Parties know what they can raise under Section 16. We are not going to give any such.
Millets will not be troubling your lordships, Millets. Will not be troubling. Please kindly observe, Millets.
Thank you.
If at all we raise, Millets, let it be a preliminary issue, so that we will not go through the whole hog of the litigation.
So arbitration gets absolutely goes for a toss. Yes.
Millets, in the absence of Millets, my instruction is that, Millets, may I just plead, Millets? Millets on instructions, millets. Permit me to withdraw that because that's what it
You want to withdraw also? All right.
Must suffer this.
Otherwise, millets, it will have the stigma of dismissal.
All right.
You only request
Item 21, then 21 years.
This comes up after notice. This is a petition under section 7 of the Arbitration Act.
Yes.
Because last time on 14th of August when the matter came up, your Lordship asked me to give 3 names of retired judges. I gave 3 names. One was Justice K.L. Vadne, Justice Davre and Justice Sarak. On the 18th of, it was listed on 18th of August for that purpose only. On that day my friend sought time and therefore your Lordship had imposed the cost of 1 lakh on 18th of August. Now, out of these 3, what happens in between is when I file a petition before your Lordship, they appoint one lawyer unilaterally without my consent and get an award passed in their favor. Your Lordship indicated to them this can't sustain. You choose one amongst retired judges or you choose any one retired judge and